Hello. Mic check, mic check. How y'all doing today? Angie Lady says that like button has been slapped like a bitch who sues over a rap beef. Oh, yes. Oh, yes, indeed. Hello, beautiful people. Shout out to everybody who's watching. Hit the like button, share the live. Let's talk, let's chat, let's commiserate, let's kiki, let's all of the things. Shout out to the best mod squad on the internet. Yes, indeed. I know some of y'all pull triple and quadruple, and double duty. So took a couple days off. Last week was very busy and we had an exceptionally long live, which is available in its entirety on Patreon. Shout out to all of the members on Patreon. Shout out to all of the members on YouTube. And shout out to all of the new members on YouTube. We have finally hit 17,000. Child, I was so sick and tired of seeing 16,500 and whatever. Like, growth is great. It's not my main focus. I just get tired of seeing the same number. It doesn't discourage me or anything. I'm like, I just want to see a different number. And we got a different number. So yeah, last week was good. Last week was really good. If y'all are wondering, the sentencing video is at over 75,000 views. Yeah. A video just going like this for now 7 days is pretty incredible. And again, much thanks is owed to everybody who watched, but particularly as we discussed in the 1 year live stream, particularly to the subscribers. When you watch a video, when you like a video, when you comment on a video, it changes where the video sits in the algo. So good job. Good job indeed. Shout out to all the silent looters. Those of you who watch but don't chat, you can drop a little heart, drop a little wave, drop the emoji of your choice. How about that? Whichever one makes you say, I'm here, but I don't have anything to chat about. That's totally fine. But we like to know you're here and we like to recognize you as well, because I can tell by the numbers of who's chatting and who's here that you're here, beloved. Yes, you are. Uh Child, so much has been going on. Um, as I said, last week was really, really busy. Lots of new people coming to the channel because of the sentencing video, several hundred of which subscribed. So if you're new, hello. I saw a lot of first-time commenters. Some of y'all didn't make the first round. You didn't make it out of the first round of your first comment on a video or on a post on this channel. And wasn't it illuminating? Yes, indeed, it was illuminating. Yes, indeed, it was. I would just like to say, particularly to the older Black male generation who's on the socials and, using the YouTubes and whatnot, it's not a good idea to have your first name, your last name, and your whole ass birthday, as your username while you proceed to talk a bunch of nonsense in a comment you attempted to post on this channel. Yeah, you're free Diddy. Well, beloved, is that because you were convicted of domestic violence, battery, contributing to the delinquency of a minor, and driving the wrong way on an interstate highway in Chicago before you beat it up to Boston? Or are you the young 25-year-old gentleman who works as a sales clerk uh-huh, at Publix and doesn't think that the posts on this channel are nuanced enough? Don't play with me. Don't play with me. Okay? If you made it past the first round, congratulations and welcome. Congratulations and welcome. Yes, I've screenshotted several examples before delivering people to the airlock. And for those of you who are new and might be wondering, what's the airlock? I've never been here before. This is my first live. Ugh, it's exciting, isn't it? Yeah, it is.
Scott, open the door. Mr. Scott, now.
If you act like a biscuit head on this channel during a live, in the comment section, you get the airlock. We don't have time for that. Now, some of you are probably like, is this the person who made the sentencing video? Yes, it is. Hi, I'm Absa. I'm a real person. I'm not AI and I'm not an internet, puppet. I'm a real person. Yeah. I'm almost 50, which I have to repeat several times because Black don't crack. And people get it twisted on these here internets, call me honey and sweetie and child and speak real condescending like to me. And I don't appreciate that shit because I have 30 years of professional experience that I lend to this platform so that you can be smarter. Yeah, yeah. So if you don't like being smart, this is not the place for you. If you don't like getting into details of facts, this is not the place for you. If you think your opinion is more important than a fact stated on this channel, think twice before you disagree. Think twice before you think you are about to disagree with me. That's one thing that people have lost the ability to discern. The difference between somebody who is presenting their opinion and somebody who is presenting actual substantiated facts with empirical evidence. You can disagree with me on my opinion about things. Like, I think Drake is a biscuit head. That's where you could say, Drake is not a biscuit head. He's the greatest rapper alive. Or whatever your opinion is. You're welcome to do that. But if I'm breaking down something technical like and factual, I state a fact about something that happened on a day, at a time, what was said, you can't disagree with that. You can't deny that. You look like somebody who doesn't have an appreciation for reality. And we need that in today's society. We need people who can discern between facts and opinion. We get into all the dozens here on this channel. But if you're here for a while and you give it a chance, you'll realize these conversations are not about Drake or Kendrick or rap or this, that. It's all deeper. It's all deeper. So if you just want to get into the conspiracy theories and you don't want to think, there are plenty of places. I'm sure somebody's live right now. You go find them and you will be welcomed. But you will not be welcomed here. I just felt the need to say that because I know there's a lot of new people. We want to set the standard right away, and I don't have a problem setting the standard right away. Play with your mama, don't play with me. That's not what I'm here for. You know, I'm, tightening up all the things I can tighten up for the second book before the decision about the motion to dismiss comes down. And I'm writing about this very thing. Nady says the internets have dumbed quite a lot of people down. Ari, knowing that facts aren't opinion. Yeah. Yeah. And so I'm not going to get into it here now. I will talk about it more at a later time. But this place where we're at right now, we're not static here. It feels like it because we're in it. We've been in it for a couple years. We're going to be in it for a few years more. But if the planet isn't destroyed by nuclear war, then this is a part of a larger phase of a critical mass of expression that is actually really important. But there is a stupid phase. There is a dumb phase, and we're right in the center of it. So I'll talk about that more in the future, but not today. Not today. So, yes, thank you for the 17,000. Let's keep it going. Yada yada, blah blah blah. Y'all are amazing. You really are. I gushed and gushed at the 1 year, and I've really just been feeling a great deal of contentment since. And contentment makes me happy. So I'm feeling real good. Okay, I wanted to give a child, I can't read that. Let me find the big version for myself. Want to give a shout out to everybody who has contributed to the to the 1 year wish list. The most expensive things on there are for cats. I just want to be clear. We had an entire conversation in the Discord about Princey needing to go on adventures. This is seemingly you can think of this as a completely frivolous person, which means you're a monster and you don't have or love pets. Or you can consider this an investment in Princey's quality of life as he gets older. And I know that he wants to adventure, and I'm committed to helping him adventure. I did a lot of research. So yeah, there's things like that. And then there's, you can buy me a gift card for lunch. People sent a lot of wonderful bath items because I'm often, I'm old. So I wake up early, I go to bed really late, but often when I'm finishing alive, I'm like going and diving into the bathtubs. Child, I got some things today. Like, the box smelled good before I even opened it. I was like, "Oh, I got to have such a good bath." I mean, I have a default bath is a great bath, but a bath with bombs and bubbles and yeah, potions and stuff, concoctions, my favorite. So, shout out to folks who have either contributed to the gift wish list or have sent special financial contributions in the past couple days because child, I've paid half of the docket bill because I sent away for a bunch of transcripts which are not going to arrive until what is it, between August and October is when I will finally get everything because they're held for certain amounts of time, but I need to have them regardless, whatever. um I got a reminder email from Pacer yesterday with the other half of the bill. I was like, okay, all right, okay, no problem. So for folks who have been contributing, quick, fast, in a hurry to help knock that down because it was almost 800 and there's like 400 left. But I can keep accessing documents for a little bit longer. So that was the first thing I looked at is when is this due? When is this due? Hopefully, if my for funsies probabilities of when we're going to get the judge's decision are accurate, we'll probably get the judge's decision before they suspend my account for lack of payment. But that's not going to happen either. It's going to happen. But this is definitely the biggest in a quarter of a year Pacer bill that I have ever had. Ever. I'm ever. This is what you call priorities, beloved. Priorities. Okay, so Some of these I said during the 1 year live, but I'm gonna be updating, because y'all are awesome. Joanne M, Tammy M, Jennifer M, Nicole E, Robin S, Demetrius, Angie B, Nora H, Fateless, Kay Lee, Fiona L, Dennis S, Charlie H, Cassidy C. It's Art with Words. Appreciate y'all. If I missed you, charge it to my brain, not my heart. I'm trying really hard to make sure that I don't miss you. Thank you to everybody who has contributed to the docket and transcript fund. Um, really appreciate it. Continue to send in that support, child. Woo. Yeah, 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 yeah. Yeah. Thank you, everybody. Thank you. Okay, so I wasn't gonna have a live about this, but I thought, you know what? It's worth the update. We can talk about other things as well. We'll take a viewer's choice on topics as well. But yes, there has been an update to the Rodney. Wrong one. Sorry, accidentally took myself off. There is an update to the Rodney O situation. And child, if you are not familiar with the Rodney O situation, and you don't even know who Rodney O is, let me see if I can encapsulate this for you. Rodney O is a producer slash composer. I'm sure somebody is watching who's like, she got it wrong. I don't really care. Okay. That's the closest and I think most accurate. We're going to say producer and composer of a song called Everlasting Bass, which is sampled in Future and Metro Boomin's Like That with Kendrick Lamar. Okay. What has come up is the Barry White Trust. Yes, the late, great Barry White. Hello, beautiful. Welcome. Says, actually, Everlasting Bass is based on a Barry White song. And so they sued Rodney O and somebody else who worked on it, Joe Cooley. Okay. This has turned into the trashiest legal drama that we have on this channel. I don't know how else to put it. We keep it factual, but it is devolved into a mess. Okay. In short, that mess can be summed up as a woman named Nicole Key. Nicole Key is a business associate of Rodney O. And in the midst of this lawsuit just, going on and, seeing what's on the docket, Rodney O had legal representation. He had bona fide lawyers, okay, at a respectable law firm. And then all of a sudden on the docket, you start seeing somebody who's not a party to the case in any way, shape, or form, named Nicole Key, motioning the court. She wants to intervene officially, and she starts filing a bunch of do this, do that, do this, do that, which in federal court is, it's not unheard of, but it is rare. It's rare, okay? And very shortly thereafter, because she was relentless and wouldn't stop, Rodney O's lawyers withdrew from the case. This left him and Joe Cooley representing themselves. It's a term called pro se. You'll hear that a lot here. The court is managing it. This judge has dealt with a lot in her career, so she could deal with this. Even though Nicole Key is not a party to the case, she's still involved. She's still helping. She's still apparently using ChatGPT. They both are, apparently, to respond to legal things, to write legal things. And they have filed motion after motion after motion after motion after motion. Sabra, thank you for your contribution. And they have been denied. Okay. Nothing has gone well for them. Then they decided that Rodney O and Nicole Key decided, separate from this, to sue Epic Records, Sony, Future, Metro Boomin, Kendrick Lamar, the Barry White Trust, attorneys for the Barry White Trust, John Doe's 1 through 10, and a couple other entities for a bunch of things. Okay, it's just that's honestly the best that I can give you right now, because I'm trying to just catch you up and also like just get to the point. So that has not really gone anywhere because they haven't served any of the parties. Nevertheless, we're left with the original lawsuit. So we've got two lawsuits. We've got the Barry White Trust suing Rodney O and Joe Cooley, who are being assisted by Nicole Key and her ChatGPT. And then we've got Nicole Key and Rodney O, who are suing the Barry White Trust et al. Not moving anywhere because they haven't served the parties. So it's been ratcheting up on the docket. The Barry White Trust is starting to get fed up with all of the completely nonsensical motions and complaints and claims that Rodney O and Joe Cooley, but mostly Rodney O, put on to the docket, because it increases the amount of time that they have to, dropping knowledge bombs with the assist on the channel. Thank you. They have to do more work, which means they have to charge their client more money. And you can be found responsible for opposing counsels or opposing parties, legal fees, costs, etc., if it is found that they are having to do work because you're doing frivolous, nonsensical, malicious things on the docket that are literally wasting everybody's money and time. And so the last time we gathered to talk about this case, the Barry White Trust had finally gotten to the point of saying to the judge, because Rodney O is forever standing up and screaming, they won't give us this and they won't give us that, and this is discovery and they have to give us everything that we want, and blah, 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 blah. The last time we gathered about this case, the Barry White Trust had major receipts, pointed questions about, because when you are in discovery, in case you don't know, documents and the like are held electronically via a third-party company, typically. And all the parties, the actual parties involved, have access to them. Well, that access is tracked. And so while Rodney O is screaming at the judge, they're not giving us this, they're not giving us that, the Barry White Trust came back and said, actually, they have access to this and that. And who at this IP address a block away from Nicole Key's house is accessing these documents if you don't have access to them? Furthermore, Your Honor, you need to warn these people, because the court has to warn them. They're about to start incurring oppositional costs. So case law and rules say they have to be warned. So the Barry White Trust said, we need you to warn these people because we're going to start going after our costs and our time that our client has to pay because these biscuit head ass motherfuckers, yeah, that's how we get down, are acting a whole entire fool. And it's costing us time and it's costing us money. So today on the docket, we got an update. And make sure I'm looking at the right thing. Yeah, okay, good. Oh, we're going to look at two things. There were quite a few exhibits attached to this letter to the judge, written and filed today, but we only got to look at the letter and one attachment for you to understand the what the fuck are you doing that we have hit today. This is the eternal question with this case is WTF are these people doing? It is just a blatant disregard for process, no deferential respect to the court. I mean, there are times we've come up with a new word in the lexicon contributed by Fateless and Fateless's niece, a dazed. We'd be shocked and a dazed reading these documents of like, what are these people doing? So largely, this is why we follow this case, because we follow a lot of examples of what to do, and we talk about strategy. We break down strategy, and we're learning, right? So, but this one is a consistent example of what not to do. In the event you find yourself, and it happens for legitimate reasons, it can happen. You find yourself having to represent yourself in a situation, whether it's criminal, civil, or administrative. Administrative, what does that mean? It means your job. It means your school. It means an incident that happens with you and a third party out there in the world, and they have an administrative process. I don't care if it's a dispute with the phone company. It could be something much more serious. Hi, Mark Creasy. So today, the Barry White Trust sent this letter to the judge. And yep, there's a lot of legal stuff in here, but it's not long. It's 2 pages. And then we're going to cut to their first attachment because Dear Judge Coate, on behalf of the plaintiffs herein, we write pursuant to Rule 2C of the individual practices in civil cases of this court and Local Civil Rule 37.2 of the Southern District of New York to request an informal pre-motion conference with respect to a discovery dispute. What does that mean? It means that all courts have rules, and the rules are based on the level of the court. Okay? Your local backyard court, municipal court, where you go and you pay a traffic ticket, they have rules that are established. And it just goes from there all the way up to the federal level. So you have local rules, and that's like everything, again, from your backyard up to your state, right? Because state can prosecute, state can sue. And then you have your federal rules. There are district rules. Like there's just layers and layers and layers of how you do what you do in a case, the sequencing, okay, the consequences for not doing it properly. But so it's a lot. You have to take into account, make sure you are accounting for several different layers of rules when you are handling a situation. And so they are bringing up the individual practices in civil cases of this court and the local civil rules of the Southern District of New York in a discovery dispute. And again, if you've been here, who is surprised that it's a discovery dispute? Not I, said the fly. Not I. To date. And notwithstanding the defendant's unrelenting onslaught of letters and filings, charging us with making false claims and other misconduct, the defendants have produced nothing. Not one single document to support any of their claims and or defenses herein. They have simply and willfully ignored our discovery demands and have refused to schedule a meet and confer. We talked about this last time, to discuss any discovery issue. So we talked about this 2 weeks ago. They were trying to get a meet and confer. And what did they say? Judge, we're going to follow up with you in 2 weeks when discovery is technically over and address at that point in time if there are any issues. And here they are. 2 weeks to the day, airing it out. So they have simply and willfully ignored our discovery demands and have refused to schedule a meet and confer to discuss any discovery issues, even the discovery issues they have raised. That's not working in good faith. And what do courts like? Parties that work in good faith together. Yes, they do. The courts really like that. If you can't do that, you might be the problem. Pursuant to the scheduling order herein on docket 80, on May 16, 2025, plaintiffs propounded on defendants their first request for the production of documents and their first interrogatories to defendants. That just means they gave them 2 things. Their first set of document requests, this is from the Barry White Trust to Rodney O and Joe Cooley. So they gave them a list of, we've looked at discovery before in Drake v. UMG. And that was document requests. That's what we looked at. But when we went through that, I told you there's also a thing called interrogatories. And that is what we're gonna learn about today. Interrogatories are either really boring or really, really, I'm just going to be honest with you. They can be really fun because basically you get to ask anything. 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 I've been a part of building interrogatories before. And yeah, depending on the situation, the questions that you're asking are 1, probing, 2, gonna piss them off when they read them. Gonna piss them off when they read them. And 3, they have to be answered, or they have to show good cause as why not to answer the question, but they have to answer the question. So interrogatories, yeah. It just depends on what side you're on. If you're receiving them, they suck. And I've yeah. So, but if you're delivering them, great. Really great. So in May, Barry White Trust gave Rodney O and Joe Cooley their first set of document requests and their first set of interrogatories, that's questions to the defendants. Defendants' responses were due on June 13th, 2025, and defendants neither requested nor were granted any extension. Okay, well, I think that's going to be irrelevant, or they wouldn't have put it in here. On Saturday, June 14th. Defendants emailed a document entitled Defendants' Responses and Objections to Plaintiff's First Set of Interrogatories. So Joe Cooley, Rodney O, sent a document on June 14th, the day after they were due. And this is their responses and objections. And you can object. And I've said this before, you can object, lawyers can object in a deposition to a question. They'll say, we object because blah, 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 blah. And then they'll look at their client and they'll say, answer the question. We went over this in the Daystar Peterson deposition for Megan Thee Stallion's lawsuit against Milagograms. So, you can jot down your opposition or concern or objection too, but you got to answer the question or be prepared to show cause to a judge as to why. So a day late and $1 short. They sent in their responses. The defendants' interrogatory responses were both incomplete and deficient, and the defendants did not provide any written responses, objections, or provide any documents in response to the first document requests. They didn't answer the questions. They didn't provide any documents requested. And then they say, on June 25th, we sent a letter responding to the issues and defects of Rodney O and Joe Cooley's discovery responses and failures to respond. Exhibit A, that's what we're going to look at. The deficiency letter clearly addressed the discovery issues, among which were that the defendants rewrote the interrogatories and responded to at least 12 self-altered interrogatories. Defendants' failure to respond to the deficiency letter prompted plaintiffs to send another letter dated June 30, 2025, Exhibit B, requesting to schedule a meet and confer. On July 2, Mr. Oliver wrote that they flatly refused to produce any of the plaintiff's outstanding discovery. A copy of that email is Exhibit C. Plaintiffs responded to the defendants on July 8, advising that we would inform the court of their refusal, that was yesterday, to meet and confer regarding any of the discovery issues which have been raised. A copy of that letter is Exhibit D. And then they go through a bunch of shit. Okay? Defendants' failure to produce even the most basic documents in connection with their defenses or in support of their spurious claims against plaintiffs and counsel is unacceptable. Since defendants have failed and refused to make disclosures or cooperate in discovery herein, plaintiffs wish to seek relief. You're going to have to start paying attorney's fees. You ain't even got an attorney. Under Federal Rules of Civil Procedure 37A and D, as well as the inherent powers of this court, if the responding party fails to produce documents, the party seeking discovery may move for an order compelling an answer, designation, production, or inspection. Case law. An order compelling production of documents and or answers to interrogatories is entrusted to the sound discretion of the district court. Defendants' failure to respond to plaintiffs' discovery requests leaves plaintiffs with no choice but to seek the court's intervention to compel responses and production. And then again, more case law. Despite defendants' pro se status, they are expected to equally comply with discovery requirements set forth by the Federal Rules of Civil Procedure. Case law. There is no justification here for the defendant's refusal to respond or communicate with the plaintiffs. Plaintiffs also intend to seek relief pursuant to Federal Rule of Civil Procedure 37A5. If the motion to compel is granted, the court must, after giving an opportunity to be heard, require the party or deponent whose conduct necessitated the motion, the party or attorney advising that conduct, or both, to pay the movant's reasonable expenses incurred in making the motion, including attorney's fees. Plaintiffs respectfully ask that the court schedule a conference to address these outstanding issues and issue an order granting leave to make their motion to compel as set forth above. The judge said, "I will see you in 2 days in court." I will see you in 2 days in court. Yeah, that was the judge's response. She didn't wait for a response from Rodney O. There was no respond within 7 days. It was 2 hours later, order on the docket. I will see your ass in court on Friday at 2:30 Eastern Time. Let's look at what they did. And you can't do this. Okay? Let's look at Exhibit A. This is a letter from the attorneys for the Barry White Trust to Rodney O. Dear Mr. Oliver, as you are aware, your written responses and objections to plaintiff's first requests, it's going to be known as the plaintiff's FRP, for production of documents and plaintiff's first interrogatories were due to be served by no later than Friday, June 13. You were also to have begun producing documents responsive to plaintiff's FRP on that date. As specifically set forth below, this letter addresses the multiple deficiencies and failures in the discovery responses you have provided to date. This is documentation. This is a receipt for that ass. So this is going to give you a clear idea of what an interrogatory is, what you're supposed to do, and what you don't fucking do. So you failed to provide any written responsive to our FRP. You have also failed to produce responsive documents. And then, yeah, we demand that you get your shit together and give us our stuff. And then, she tells them what it is. She literally gives them directions, which is generous for her, from her. For clarity, and to the extent you intend to claim that you do not possess documents or materials which are responsive, you must provide the following information: whether any responsive documents or materials exist or ever existed, whether any responsive documents or materials ever existed in your possession, custody, or control, and if the answer to either one or two is yes, then identify those documents, describe the steps you have taken to obtain them, and explain where they can be found or why they no longer exist. So, again, she's helping them there. She wouldn't have to tell a lawyer that because a lawyer would know. And she's trying to be efficient. She's this back and forth tit for tat with people that don't know what they're doing is costing her client money. So her putting this in here is her attempting to inject inefficiency of don't respond with some bullshit. Per the rules, respond formally as you are supposed to. On Saturday, May 14, you served via email defendants' responses and objections to plaintiff's first set of interrogatories. In addition to the specific deficiencies which we particularize with respect to each interrogatory below, we note the following deficiencies. You have failed to respond to each interrogatory to the extent it is not objected to under oath. You have failed to timely respond to plaintiff's interrogatories. To the extent you have stated objections, you have failed to state them with specificity. You have failed to comply with the number 34 of the instructions for plaintiff's first interrogatories, which clearly provides that each interrogatory should be quoted in full immediately preceding the response. So before you put your answer, you restate the question exactly as it was asked. Copy paste, then put in your answer. Copy paste the question as they asked it, and then put in your answer. This is important. This is an important detail. They're given instructions. You have failed to comply with number 34 of the instructions for our first interrogatories, which clearly provides that each interrogatory should be quoted in full immediately preceding your response. So copy paste, then put your answer. That's your full answer. If you don't follow those instructions, you're not answering the question. As set forth below, in most cases, you have failed to quote the interrogatory in full prior to responding, and it appears that this has resulted in confusion and non-responsive answers. It appears, oh, we've talked about this so many times. Look at that right there. Yes. It appears that you created your answers to the plaintiff's first interrogatories using AI-generated responses. We respectfully request that all records relating to the creation of your responses be identified and retained for discovery purposes and be provided. Oh my God. Oh my God. Oh my God. What'd I tell y'all? This is the best call out ever because they've said it they've said it a couple times. I've said it from day one. Day one. Oh my God, they think ChatGPT is actually intelligent. Bias language model. We've gone through the whole breakdown here. To see them say, we respectfully request that all records relating to the creation of your responses be identified and retained for discovery purposes and be provided. So that is a formal document retention notification from one party to the other. They have to do it. You know what's interesting is I actually alluded to this many videos ago on this topic. Yeah, many videos ago on this topic, I said, if you are going to fix your face to say that you don't use ChatGPT, you are going to have to hire an independent third party who you hand all your devices and accounts over to prove it. Because you clearly do. Here's an example of an interrogatory. You see it in bold there, okay? That is the first question that the Barry White Trust asks Rodney O / Joe Cooley. State the name and address of the individual signing the answers to these interrogatories and each person who was consulted in connection with answering these interrogatories, indicating the specific interrogatory that each person was consulted in connection therewith. That is the question. Now, class, in order to get a good grade on this practicum, I, your instructor, have provided you with what instructions? What's instruction number 34? That's right. Copy, paste, type your answer. Okay? Identify name and address of the individual signing the answers and each person who was consulted in connection with answering these interrogatories and which interrogatory they helped or consulted on coming up with the answer. Rodney O wrote, identify each person who assisted you in responding to these interrogatories. Your response, Rodney O, defendant Adder and Jackson. Oscar is here. Welcome to the channel. Let me think. Give me a second. I promise you, this cat is sitting here staring at me. And I've got princey furniture everywhere. Thanks, Fateless. I gotta move some things around so I can open the door. I wonder if I can pick him up and actually show you him. He's waiting. He knows I have food. If you're wondering why we stop for cats, because we're not monsters, number one. And number two, because this channel keeps my cat and my stepcats who live out there in the wild well fed, to the extent that they just walk up to my door. Hey, lady. Okay. Fine. This is Oscar. Oscar's like, food. We're just making all kinds of milestones on the channel. As soon as I lifted him up, he was like, the bowl's right there. Hey, lady. I don't know what he's being a picky butt for. Now he's sitting there staring at it. Let me give him one more thing. Hold on. If you're wondering if the cats really do get spoiled, yeah. What are you doing? I gave him some catnip nuggets. He's very happy. Okay. Fur baby taken care of. 100,000 subscribers. Maybe we'll see Devil and Demon. I don't know if that's ever going to happen. Okay. Before we had to take that very important, visitor. Oh, he really likes. I can't remember who set these in, but the catnip squares. I probably gave him more than I should have, but he's an outdoor cat. How often does he get? I mean, he's a alley cat. How often does he get luxury catnip? I'm happy for him too. Now he's like, okay, now I want all this dinner. Now it all tastes good. That's funny because I know there's kibble in the front, and he probably went up to the bowl and was like, no. Let me go around back, see if she's there. Oh, look, there she is. Hey, lady. Oh, good. He's eating. Okay. All right. So Rodney O did not answer the question. Okay. He did not copy paste. He rephrased the question and then put in a deficient answer. We know it's deficient. We know it's deficient. And that legally means you didn't answer the question. So it's non-responsive, and there's no objection. So you didn't object to the question. You just didn't answer it. So no objection. You failed to provide a complete response, including but not limited to answering Jackson's address, as well as the specific interrogatories regarding which you conferred with the individual. Please update the response and confirm that all responsive information has been provided and is accurate. He knocked the bowl off the table. Yes, he has a table. Again, dignity. Interrogatory number 2. Identify the manner and technology in which each of the defendants developed and created Everlasting Base, as well as the existence, custodian, location, and general description of any documents relevant thereto. Instead of copying and pasting that, Rodney O wrote, describe in detail the creation of Everlasting Base, including authorship, production, recording, and instrumentation. None of those words are in the question. Rodney O's response. Objection. Overbroad and unduly burdensome. Subject to and without waiving objection. Everlasting Base was recorded in 1987 at Skip Sailor Recording using analog equipment. It's unduly burdensome for you to identify the manner and technology in which each of the defendants developed and created Everlasting Base. You don't know. You can't describe between the two of you who did what to create this song. That's overly burdensome to describe a studio session. Why? Overbroad. It's direct as fuck. You say it's your sole creation. And it's not based on a Barry White song. So if it's your sole creation, then it is directly relevant for you too. Identify the manner and technology in which each of the defendants developed and created everlasting base, as well as the existence, custodian, location, and general description of any documents relevant to that. Interrogatory number 3. Identify all individuals by name and address involved in writing, developing, and creating everlasting base. Rodney O wrote, identify the persons who authored everlasting base. That's not the question. That's not even that's not even a proper rewording of the question. That's not the question. This goes down in comment history for me. Angie, thank you for the support. Appreciate you. This comment right here. Rodney O. The O stands for obtuse. Identify all individuals by name and address involved in writing, developing, and creating everlasting base. He translated that into identify the persons who authored everlasting base. Rodney Oliver. Well, we know that's not true, sir, because you're not the only one being sued. You have propounded no objection to this interrogatory. Your false recital of this interrogatory limits the scope of the inquiry, and your response appears to be incomplete. For example, there are multiple copyright registrations for everlasting base, which includes the names of other individuals listed as authors, including but not limited to Joe Cooley and Jeff Page. Describe in detail defendant Oliver's and defendant Cooley's business relationship when creating everlasting base, including but not limited to the financial terms. Rodney O translated that into identify each person or entity with an ownership interest in everlasting base. Where do you get this language from? It's a rhetorical question. Where are you getting this language from? It's not even accurate. It's not even an accurate summary rephrasing of the question. It's a rhetorical question. Hi, Kiki. His response was solely as it pertains to the issues in this lawsuit. Rodney Oliver is the owner of the composition Everlasting Base. You didn't answer the question. Solely as it pertains to the issues in this lawsuit? What? So you're saying there's ownership of the song, but then for the purposes of this lawsuit, there's a different list of owners. Plaintiff did not request your assessment of what ownership interests pertain to this lawsuit. This answer is non-responsive and incomplete. Jesus Christ. She's getting upset. Interrogatory number 5. Describe in detail any authorization you have received to copy or otherwise use plaintiff's work or any element of plaintiff's work, including who provided the authorization, what rights were granted by the authorization, the terms and conditions of the authorization, how the authorization was communicated to you, and the date you obtained the authorization. Rodney O rephrased that to state whether you receive authorization to use plaintiff's work in everlasting base or like that. So, do I understand correctly that this man needs ChatGPT to translate these questions because the questions are too sophisticated for him to understand? I'm just asking. Kim Tillman, maybe it's not lying if you don't answer with any sense. These are the most basic ass questions ever. Goldie, these questions are not complicated at all. At all. Not complicated. And for somebody who just the other day was arguing that any reference to like that should be stricken from the record, here he is injecting it again. Again, rhetorical question. Why would you need these questions interpreted for you, inaccurately restated to you, for you to feel capable of answering them? Why not just answer the fucking question? Defendants deny any use of plaintiff's work. No authorization was required or received. That was his answer to his own question. Because he didn't answer the question. It doesn't count as an answer. No part of it counts as an answer. That's what you have to understand legally. Restating shit, you did not answer the question asked by opposing counsel. It doesn't matter what the fuck you put there. You didn't answer the question. It's non-responsive. Identify all individuals by name and address who conducted reports, studies, surveys, investigations, research, development, analysis, or opinions concerning this action or plaintiff's work, including but not limited to any such documents comparing Everlasting Base and I'm Gonna Love You Just a Little Bit More, Babe, or concerning any similarities between Everlasting Base and I'm Gonna Love You Just a Little More, Babe. Your false recital of this interrogatory. Identify any expert who has provided analysis in this case. And your response. Defendants have not retained any expert at this time. Plaintiffs have not produced any deposited sheet music or other materials that would allow for a meaningful expert analysis. Nigga, you are a joke. As plaintiffs' claims involve a composition allegedly created before 1978, defendants, oh, he's still on that bullshit. Okay. Defendants reserve the right to retain an expert after receiving such materials and will supplement this response accordingly in compliance with Rule 26A2 in the court's scheduling order. Interrogatory number 8. Identify all individuals by name and address in connection with the offer, discussion, negotiation, or execution of any licenses or other agreements, including indemnification agreements in connection with the song Like That. Rodney O's revision. Rodney O's revision of the question. Identify all attorneys consulted about this dispute. And then he offers some names. Well, nigga, again, we know, number one, you didn't answer the question. Number two, we know that's not true. By shit you put on the docket. Who'd you put on the docket? Nicole fucking Key. Who did the negotiating? Nicole Key. Who said that? Nicole Key. Who agreed? You. Why is this difficult? I don't fucking get it. Your false recital of this interrogatory completely changes the question being asked. For example, Nicole Key was clearly involved as an individual required to be identified. Thus, your answer is non-responsive. Interrogatory number 9. Identify all communications that defendants and anyone on behalf of the defendants jointly or individually posted on the internet, including but not limited to any social media regarding this action. Rodney O rephrased that to identify all social media posts you made regarding this litigation. Response: none. Deficiencies. You have propounded no objection to this interrogatory. Your false recital of this interrogatory limits the scope of the inquiry and changes the question being asked. Thus, your answer is non-responsive or incomplete. Update the response, ensure that it's complete, and confirm that all responsive information has been provided and is accurate. For example, Nicole Key was clearly involved as an individual required to be identified. And nigga, you know she is because you tried to convince the court that it was unreasonable that the court should have Nicole Key sign a confidentiality agreement or order. And you can't control what she does or what she says out there on the internet. You fucking did an interview. What the fuck is happening right now? You did an interview. You posted about it. What? He's never going to get one, Alcatraz. We are watching the train go off the rails. Dude. It defies reasonableness. It really does. It defies reasonableness. We don't work on this case. We catch up about it over lunch. And we can look at these questions and go, well, that's not true. Because you're the one who said XYZ. And that's that Identify all communications that defendant Oliver's rights manager, Nicole Key, or Lady Key Management posted on social media regarding this action. Rodney O revised that to state all facts supporting your contention that plaintiffs lack ownership in the copyright material. I'm going to go out on a limb. Okay, I'm going to go out on a limb based on that situation right there. Interrogatory number 10. Somebody is deficient. Somebody is deficient. Those aren't even remotely similar. Fateless is disgusted. Fateless is disgusted. But I'm going to go out on a limb here and say that there is a human deficiency. Somebody is intellectually compromised. You had weeks and weeks to answer these questions. You submit them a day late. You don't answer the questions. You don't even properly rephrase the questions to get something close to a properly responsive answer. And then you just go completely off the fucking rails. Identify all communication that defendant Oliver's rights manager, Nicole Key, or Lady Key Management posted on social media regarding this action. And your response was plaintiffs had not identified or registered the specific musical element allegedly infringed. Defendants reserve the right to supplement following expert review. Am I high right now? It's disorienting. It's disorienting. Interrogatory number 11, identify all revenues received from Everlasting Base for the last 6 years. Rodney O changed that to state all revenue received in connection with the accused work. Your response. Defendants will produce non-privileged responsive documents sufficient to show revenue, if any, in accordance with the protective order. Nigga, we know you got at least $50,000 because you said that already. That's how you paid for a lawyer. What the fuck are we talking about? What are you doing? You said you got upfront money, and that's how you paid for the lawyers that dipped when your girl went rogue. You said that. Why don't you just repeat what you done said? Oh my God. My eyeballs almost got stuck. I rolled them so hard, so fast. Interrogatory number 12. Identify the total amount of monies received from granting a sample of everlasting base, which includes a hook from plaintiff's work. Rodney O changed that to describe the musical similarities and differences between everlasting base and plaintiff's work. And then responded, objection. Calls for expert opinion. Subject to and without waiving, everlasting base is an original composition that does not replicate the musical content of plaintiff's work. Kiki, how did bro completely remove anything about money? Goldie, that's not, or Marshall Irons, that's not even close. Goldie, that's a whole different question. Kim Tillman, imagine poorly restating the question and then objecting to it. The nerve. The nerve. I think so because this is stupider than ChatGPT. I know for a fact it's dumber than ChatGPT. He used Grok, the trial version, because ChatGPT is not this dumb. No, ChatGPT is not this dumb. I mean, it's not intelligent to begin with, but it's not this dumb. It did exactly. It feels way too bad to be ChatGPT. I know this because I've written and published a lot of stuff over different platforms, and so there will be something that I've written already, and I'm like, I need to say the exact same thing. I need to start in the same place. I need to make the exact same points, and I need to end in the same place. But because this was published over here, I can't also publish it over here, so I need all different words. I need all different words. And this is not what Chat GPT be suggesting, Angie lady. This is deeply bewildering. It is. This is why I said at number 10. Do not operate heavy machinery under the influence. And in this case, heavy machinery is Chat or Grok or whatever it is that you are using. When you are dealing with a procedural situation, a formally procedural situation, try and be sober. Make sure you get a lot of sleep, so you can read the words on the page. What do I always say? Answer the question asked. Do you see why I'm losing it? That is an ABSA life law. Answer the question asked. Do the task you were given. Before you want to go impressing your new boss or your coworkers, did you do the task that was assigned to you before you decided to go rogue and do something else that you thought would impress everybody? You're not a reliable colleague who knows how to follow fucking directions, and you don't have an appreciation for the processes and sequencing in which we do things here. That's the real world. I don't know what the fuck this is. My concern is that even if you got confused in the copy and pasting of what was in Grok versus what you were putting in your, Word document that you were submitting as your answers, what are you supposed to do with your final draft? Read it. Yeah, you read it yourself from beginning to end, the whole thing, every fucking word. And then, you know what happens when you do that? You identify your own mistakes and you correct them. This is I don't know. It's like pin the tail on the interrogatory. Blindfolded. That's what this is. It's nonsensical. I'm like, no way. Nuh-uh. Poorly restate and then object to your own fucking question. Oh, Jesus Christ. Identify the total amount of monies received from royalties or other income, including synchronization income from like that. Rodney O changed that to identify all royalties you have received in connection with the accused works. No. Your response, objection, overbroad and not limited in time. Well, it is limited in time inherently because the song was released at a very specific time. Memorandums of agreement went back and forth. You attach them to the new lawsuit that you haven't served any of the parties in. We know this. This judge knows that because she's been assigned that lawsuit. So she's read it and knows. Subject to and without waiving, other than it disclosed in response to interrogatory number 11, no additional royalties received. Did you answer interrogatory number 11? You didn't answer interrogatory number 11. How you going to refer to interrogatory 11 like you answered it? You didn't answer it. State the annual gross receipts received in connection with the reproduction, redistribution, display, performance, sale, or other exploitation of defendant's work, including but not limited to like that, including identifying the methods used in calculating net profits. Rodney O changed that to state the total gross income received from the exploitation of everlasting base. And then said, objection, vague and unduly burdensome. Subject to and without waiving, defendant will produce documents sufficient to show gross income, if any, in accordance with the protective order. Well, these interrogatories are in accordance with the protective order. What is the matter with you? Interrogatory 15. Describe in detail all facts that concern, support, or refute any claim by you that plaintiff's work is not copyrightable, as well as the existence, custodian, location, and general description of any documents relevant thereto. Let's just go over the actual question one more fucking time before we get to the answer. Describe in detail all facts that concern, support, or refute any claim by you that plaintiff's work is not copyrightable. He revised that to identify any prior works you claim are sources for plaintiff's work, and then said, Jackie Me Too's instrumental catalog contains similar baselines. Plaintiffs have not demonstrated originality. I thought you said there were no experts. Why are you offering an expert answer? I just cannot. Identify any gross revenues received in connection with the exploitation of defendants' work that you claim are not attributable to the infringement of our work, and describe in detail the basis for your claim. He revised that to identify all revenue you received unrelated to plaintiff's work. Objection. Overbroad. Like, I don't even know what this fucking objection is, man. This is I don't know, man. Grok sucks. Grok sucks. She asked about counterclaims, and he translated that to identify all documents supporting your defenses. Objection, overbroad, blah, 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 blah. Overbroad. What about Cooley's counterclaim? And then in here, after you said nobody else contributed to this song, Joe Cooley contributed to the original 1987 recording of Everlasting Bass. This nigga gets no titties ever again in life because I said so. Just needed that over with. I needed it over with. Who was it that brought this case to ABS's attention? I'm not sure if we need to hug them or hit them. It was neighborhood therapist. I'm pretty sure it was neighborhood therapist. I could be wrong. Yeah, so judge said, I'll see your dumbass in court on Friday. She didn't say that, but she said, yeah, we do need to have a conversation. We sure do. So that's that on that. Don't think it's going to go well. Don't think it's going to go well. What else is going on, folks? How you doing? What's going on? What's going on? This is facts. Bad case. Great content. It just defies reasonableness. It really does. As you can see, I wind up in the same place every time there's an update. What are you doing? What is going on? This makes no sense. And they are You know, I've been saying this for a while. I'm impatient with people fucking around. The courts, you know, tend to initially give a wide berth for pro se litigants because they're not lawyers, and the court tries really hard to look at their actions in the most favorable light possible. They're making that more increasingly difficult as the days go by. You know, the last time we gathered, she denied them a bunch of shit. Yeah, I don't think she's granted them a motion for a fucking thing in quite some time. Everything has been denied, 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 denied. And they just keep filing the same shit over and over again like it's debatable. Without a new argument, without a new, it's just, it's exhausting. And again, it's costing the other party attorney's fees and costs. So I said a while ago, somebody needs to nip this shit in the bud because it's fucking annoying. But again, I'm impatient when it comes to biscuit head assery. So, but I think the hammer is coming down. This is the second letter that they have sent to the judge. Firmly, Your Honor, what the fuck? And they've had it. Once they were pulling IP addresses for who's been accessing discovery, I was like, oh, Barry White Trust is taking the gloves off. They're tired of this bullshit. They're tired of people LARPing as lawyers and fucking shit up. And they want them held accountable for that. And I think it's perfectly reasonable. It's perfectly reasonable for a judge to say, this is a motion to compel. You better answer these fucking questions within 7 days. And opposing counsel needs to submit to the court time and costs to draft this letter to the court and to respond to put together the non-responsive letter back to Rodney O that we just read. How much time did it take you to do that? That is now on Rodney O and Joe Cooley to pay. It's coming. And the more they do that, the more the judge is just going to be like, I'm charging you for that. You can get charged for the stenographer. They're very expensive, as we've discussed. Transcripts are $9 a goddamn page. Transcriptionist time. Transcriptionists can cost more than some lawyers. Yeah, this is where I'm at too. They're past time for, you know, oh wait, no, this wasn't the one I was gonna, this was it, sorry. They're past time to have gotten their acts together. Yeah. And he submitted a letter to the court today, as a matter of fact, where he was like, where he, you know, was basically trying to kiss the judge's ass. And one of the first things he says in his letter is like, you know, I'm doing my very, very bestest, Your Honor, to make sure that I'm complying with the confidentiality agreement. And Nicole Key has signed it, Your Honor. Nigga, we know. We know. Because if she hadn't signed it, opposing counsel would have said something to the judge. You had a month to answer basic questions about something you claim is your own asset. It's not overbroad or overly burdensome to answer those questions. And no judge is going to agree with you that it is. No judge. No judge is going to look at the Barry White Trust interrogatories and say, those are unreasonable, overbroad, burdensome questions. That's bullshit. That's bullshit. That judge is going to snatch your fucking edges on Friday. He doesn't have a lawyer. He too is pro se. They're all representing themselves. Joe Cooley was represented by the same lawyers that Rodney O was represented by. So when they both lost their lawyers. When Miss Self-Important entered the chat and said, me, 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 me. Do this, do that. Do this, do that. Exhausting, irrational, like legally manic behavior. And I don't mean like I'm declaring that they're legally manic. I mean, in the legal arena, that shit's manic. That shit's manic. That's like third year law student hasn't slept in 4 days because they're doing mocks before Supreme Court clerks or some shit. I don't know. It is like, under what conditions did you sit down and prepare this document? That's the most gentle way I can say it. Under what conditions did you sit down and answer these questions? Did you get a wisdom tooth pulled that morning? They gave you a little bit of laughy gas. You couldn't see straight. Like, beloved, they asked about Nicole Key's social media posts, and your response was revenue? Under what conditions? Under what conditions? You get LASIK? LASIK is a great answer. That's a great answer. LASIK. Couldn't see. Thought I put the answer in the right space. Oh my God, J. Ray. I would boot you out if it wasn't so accurate. Because I'm so disgusted by the fried bologna. You just reminded me of somebody. It's not your fault. You can stay. J. Ray says, I can tell you the conditions: 4 blunts, Hennessy, and a fried bologna sandwich. Oh, fuck you and him. Not Rodney O, the other nigga. Like 30 years ago. Shit. Ugh. Ugh. Oh, I'm traumatized. Oh, I'm triggered. Oh, bad memories. The grape. Swishers. Oh, oh, Fateless. No. No, 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 no. You're just crushing my illusion of your innocence right before my very eyes. Oh, make it stop. That's a good one. White noise. Hi, beautiful. His false recitation of absence interrogatory. Where were you when JFK was shot? That's the perfect equivalent. My question. Under what conditions did you answer these questions? Rodney O's rephrasing. I was not on the grassy knoll when JFK was shot. Nigga, I didn't ask. First of all, how old is you? Second of all, I didn't ask you that. Oh God. Why don't you just get some fucking Mad Dog 2020? Call it a fucking day. Ew, gross. What's that orange liquor? Tanqueray? What is it? Oh God. Oh God. I'm too old for this shit. I'm too old for this shit, okay? Oh, the green bottle? I'm too old for this shit. Melvin Matthews, thank you for the $5. Thank you for the $5 super sticker. Appreciate you. No, it's not Jaeger. It's Tanqueray. Isn't that how it's said? Yes. Wait, is that? It's a Q, not a G? Oh, oh, this is so bad. Oh my God. Oh, I have a headache just looking at it. And why? What's that one? There's a purple one? This shit right here is some nigga with no taste ass drink right here. I said what I said. Up your game. I said what I said. There's a goddamn black currant. No. But this one right here. Oh God. No reasonable decisions were made. Obviously. No, I can deal with a gin cocktail, but not with that. No, that is just trauma and bad decisions in a bottle. No. And it looks like cleaning concentrate. And here's the issue. All of the popular alcoholic beverages of the early 90s looked like some kind of cleaning solvent. Even Mad Dog. Those bright colors, Fireball, those bright colors, man, nah, that's eating through a bunch of different things. Yeah. You got grease you can't get off, that shit'll do it. No. Tasted like it too, you damn Skippy. This is the other thing. It's truly an honor and a privilege to have graduated from, drinking to get fucked up as a young person and drinking because, oh, this cocktail is quite nice. when paired with this steak. Oh God. Fabuloso colors. Fireball was the devil. Fireball was the devil. It was the devil. It really felt like, oh, my stomach just had a nice little twinge. Like, why do you keep saying it? Stop reminding us. Yeah. 15 to 17 was wine coolers, Old English, the nastiest shit on the planet. The Devil's Green Bottle, and Mad Dog. Was that 15 to 17? Let me think. Yeah, I mean, by the time I turned 21 and could go somewhere legally to drink, I was done. Had no desire to go. Yeah, I was done. I had no desire to go. I probably didn't have a real proper cocktail until I was somewhere between 23 and 25. Yeah, probably somewhere between 23 and 25. And that's when I was like, oh, well, this is pleasant. That's quite pleasant. A proper cocktail will change the way you approach the game. Exactly, because I didn't get it. You know, you drink when you're young because everybody else is drinking. And I never really had the fortitude for liquor as a young person. So getting sloshy drunk, getting blackout drunk, not my thing. I thank the universe for that because I know both of my biological parents were raging alcoholics. So I thank the universe for skipping me with that. You know, everybody's had their negative alcohol experiences, plural. You know, I certainly had my fair share as a young person. Like, you know, make sure you've eaten before you consume alcohol. It's just the shit you learn when you're young and dumb. But like I said, by the time I got to 21, keep in mind, I already had a kid. So just going out and kicking it wasn't really an option anyway. I had already done the things. I had already had my wild, unsupervised underage years where inevitably somebody in the group was old enough to get alcohol. So I had already really done those things. And so I think I just kind of like fell back. Like, I don't really get it per se. And then, yeah, one dinner and one good cocktail. And I was like, oh, okay. I get it. I get it. I get it. I get it. And then I spent a really long time just being very, you know, like, I drink this and I drink that, but I don't da 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 da. And you couldn't catch me drinking like brown liquor. Um, and really genuinely having developed a palate for it and appreciating it and recognizing it. And the quality of it, I would say that changed about a decade, maybe 15 years ago. So Yeah, I did not care. And I tried to. I tried. That lasted a couple weeks. And then I was like, I'm tired. I got kids. I'm tired. And then, yeah, I kept having kids. I breastfed them. I wasn't drinking. So it never really became my thing. But if I'm going out for, a nice flavorful meal, I would definitely prefer to have a cocktail as a part of that experience, for sure. So, yeah. If there's one thing I will never ever 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 drink again, it reminds me of fucking chicken and a biscuit. It's in that category of fucking never again. It's in the category of absence, never fucking again. Chicken and a biscuit, wine coolers, disgusting. Wine coolers are nasty. The aftertaste is nasty. You cannot comfortably make out with somebody after all you all have been drinking is wine coolers. It's so nasty. Gross. Killer of the moment. Killer of the moment. Wine coolers are nasty. And I don't I don't like many of the the hard whatever, the hard lemonades and the this, that, and the other. I've had all of no, no, no. I'm part of the generation where those things never existed before. Now they got all kinds of them. We're the generation that, we were the test kitchen for all the things between, a wine cooler and an actual fucking cocktail. Yeah, we were the test generation for all of those things. I've had them all. I hate them all. I don't even know if the new ones they make these days are good. I don't want to know. When I look at them, I can already taste the aftertaste in my mouth of what I drank 25 years ago. No. No. Oh my God. Oh, stop. Bartles and fucking James. Oh my God. That just takes me back to an apartment that I had where the walls were cement and the cabinets were metal. And in that apartment was the last wine cooler that I drank. And then I switched to red wine. In that apartment was the last fucking wine cooler that I drank. I had some wine coolers and I made some spaghetti with sausage. And I had dinner with wine coolers. I woke up in the middle of the night so sick. So sick. Never drank another wine cooler again. And it was the hangover from hell. It was the hangover from hell. First you're puking, in a cycle all night long. And then the next day you've got a headache. And then you've got that like dry, heavy feeling, like you feel like you still need to throw. It was awful. It was so awful. It was really bad. And I was so miserable. So miserable. And I was like, never again. And I'm just going to tell y'all that the smell of a red sauce pasta with sausage mixed with wine cooler, never again. Never. I didn't have spaghetti for a minute. And I was po. So it was a staple. I didn't need it. No. Yeah, that was a bad night. That was a bad night. But that was just probably sequencing of I didn't have anything on my stomach before I started, you know, just eating dinner and drinking a wine cooler. That's what they do on Miami Vice. They just sit in front of their TV late at night at the end of a hard day with their little microwave dinner and their wine cooler, and they just scarf them both down at the same time. I was like, well, this can't be complicated. Nope. Mm-mm, mm-mm, mm-mm. If we go somewhere to eat and I order a drink, I might not drink it for a minute. And we're getting appetizers. Why? Because I want to have a cocktail and I need to put something on my stomach. Yep. Now you're all traumatized. That's right. That's right. I needed to share my horror with you since somebody had the goddamn nerve to actually drop Bartles and James in the chat. Relive my horrible memory with me. God, that was such a long time ago. Such a long time ago. Well, that was displeasant. What else we got going on, chat? What else we got going on? I think of 1,000 things throughout the day, but I didn't write any of them down. So there we go. It was Bartles and James. It was. I couldn't think of that was behind the trauma wall. I couldn't think of that name to save my life. Kim Tillman says Lauryn Hill playing Essence Fest at 3:30 a.m. I don't have anything to say about that because apparently it wasn't her fault. I heard Essence Fest was fucked. Period. Nothing started on time. Period. So I heard Essence Fest was fucked, period. And I heard that her going on late and for as late as she did was actually not her fault. But I didn't get into it because I don't care. And I've had more important things to focus on than that. No, baby, we don't do that. We only watch channels that support the channel. At least in this house. No. Marshall Irons, quick business question. You've been dropping a lot of YouTube shorts. Do comments help elevate those, or is it just likes? It's both. It's both. YouTube has been aggressively pushing shorts, and it has definitely contributed to the performance over the last 9 days. I basically sucked it up and decided to pay for a service for shorts because I was doing them myself from scrap. And it is extremely time consuming to do that. So I stopped doing them. But as folks know, if you're in the Discord, I've been all over my analytics because of the sentencing video. And I was noticing the amount of traffic that shorts brought to the channel in less than 7 days of putting them back on was substantial. And led to an all-time record high of channel views. So I'm like, okay, at least for a couple months, I will continue to pay for that service. I don't really like it. Don't really want to because it's almost $100 a month. But I'm like, you have to invest in what you're doing. And so I look at it in that way. I'm investing appropriately in what it is that we're building here. And I believe in the channel. I believe in the content. And I believe in, doing whatever I can to, I think, also validate everything that you all have poured into the channel. By investing, I mean, I'm always investing in the channel, but you know what I mean. So, but I am very much a do it myself. Careful. I'm not seen to be promoting a biscuit head ass niggas channel. I'm a Girl Scout and I am a do it myself queen. So if I can do it myself, I will do it myself. I can technically do shorts myself. I can't manage it anymore. That was a long ass answer. If you know, you know. If you don't know, welcome. Go back through the archives. Piece the puzzle together yourself. We're not going to get into it. We've crossed our first full year on this channel being active, and we've survived a great deal of behind the scenes misogynistic, hateful, slanderous bullshit. And that's the only thing that matters. The channels with integrity who want to have authentic relationship, who believe in support and respect Black women, we've already established who those are for this channel. So if year one was round one for relationships on this channel, very few made it to round two. But the ones that did are the ones that matter and the ones that we cherish, truly cherish and appreciate. So all those red pill adjacent ass niggas are going to continue to be red pill adjacent ass niggas, and they can have that. Nady says, I can't wait to hear the outcome of the motion to dismiss. I only come here for court news. Well, thank you, beautiful. I can't wait too. I did a percentage probabilities on when, based on other decisions by this judge and in the Southern District of New York. I'm a nerd. Okay. So I looked at some data and came up with the probability. My highest percentage probability for when we will get the motion to dismiss is within 30 days of oral arguments. So that would put us at or before July 30th. So, and within a couple days of that decision coming out, book 2 will be done, because that's pretty much the last little bit that needs to be written is what's the damn decision. And yeah, I would caution folks, don't listen to people who think they can predict what the outcome is going to be. That's false. It's not complicated. They have a 1 in 3 chance of being right. So that doesn't mean they're smart. That doesn't mean that they, have high reading comprehension and actually read documents on their own instead of biting content from other people's channels and then parroting as if they came up with it on their own without giving proper credit or citation. Yeah, I wouldn't listen to those people, because those are the same people that said Diddy was going to walk out of jail just the other day. That nigga's going to prison for 6 to 10 years. Says who? Me. And the federal guidelines for sentencing. Yeah, I still put all chips on me for that one. Men are having a real difficult time with it, but I don't give a shit. Well, typically it's within 60 days. I told y'all it's going to be long. I think it's going to be 90 to 130 pages. It could be 50, but I think it's going to be a pretty long decision, because the judge is going to respond to everything that they've written and everything that they argued before her. It's not just going to be like 3 sentences. This is the order. It's going to be an explanation of the decision, and that takes a lot of time, and they have to do a lot of research, even if the judge has fully decided, and I have no doubt that she has at this point decided what she's going to do on each of the claims in Drake's lawsuit. It's the writing and the research of everything that has been argued, and then everything that supports the judge's decision. That's what takes for fucking ever. And she doesn't do it alone. That's what court clerks are for, is to do a lot of that research, summarize it, give it to the judge, draft parts of the decision for the judge. So, and they have a docket of 200 to 300 cases on average. And on any given day, 20 to 50 of those cases are actively moving on their own individual docket. So they're busy. In short, they're busy. It takes time. It takes time. And I'm okay with that, because I'm like, next week would be great. next week would be great, because like all of the nesting that I have to do to prepare for the decision will have been done for sure. Like, it's okay. She could go into labor right now and deliver the decision, and I'd be perfectly fine. I'll make it work. But if she wanted to wait, until next Tuesday or Wednesday, I will have everything in order. Yeah, it's not that far away. It's the 9th. Before you know it, it's going to be the 15th. We're halfway there. Like, could it take longer? Yes. Usually decisions are rendered within 60 days. I put this one at the highest probability is within 30 days. I think maybe the next highest probability after that was 30 to 45 days. The lowest probability was the full 60 days, and then the second lowest probability was under 14 days. So that's my for funsy nerdy shit that I do just to keep myself, just when I'm in that moment of like, I can't wait for this, because I couldn't call it one way or another. And I know that there are some OVOs who don't understand anything and read some tweets online and think that Drake won, or that the judge signaled that Drake is going to win the motion. And I didn't get any of that. I don't think any of that is true. Based on what I read, I don't think the judge gave any indicator whatsoever on which way she's actually leading. I think that she gave them a stress test in that hearing. I think she gave both sides a stress test to test the veracity of their arguments. And that's fair. That's fair. So we'll see what happens. We got about 15 more minutes. AMA, anything else going on? Anything else you want to ask about? Nikki needs a personal rage room in her home. And Drake needs therapy. D2B2, Aubrey is spiraling much like Nikki. I mean, this is... Who's surprised? No one. They were spiraling a year ago. They probably gonna be spiraling a year from now. Nikki's tweets are like, I can't believe Rock Nation made me stub my toe this morning. She's just a hateful, poisonous, toxic person. Like, Nicki Minaj and Lil Boozy are textbook dictionary definitions of toxic. T-Mac, thank you for the super sticker, beautiful. Oh, well, fuck. Rage room studies show that they make you more angry. She needs daily tea time and a new husband. Yeah, she needs yoga, guided meditation, and probably no husband. Let's try that on for size. Let's try that on for size. She's so pathetically irrelevant to the broader shift happening. I mean, broader, I shouldn't say shift, because she's not irrelevant to that. She's a central catalyst to why we're like, I'm gonna go over here. She's not central to what the culture feeling. And she knows it, and she can't stand it. And this is how she copes with it. This is what works for her. Because, of course, it's not her fault. It's not because she's a terrible fucking person. just a terrible fucking person, which she thinks is all valid and justified because other people did her wrong back in the day. That is a rich, privileged bitch's explanation for being a shitty ass fucking broad. They did it to me then, so I'm a bitch now. Fuck you. You don't even go here. Have a good night, Angie lady. So I don't take her seriously. I don't pay attention to her. Jocelyn, Kelly, did you know that someone leaked the Clips album just to be petty? I'm waiting to hear it on release date just to support the group. Yeah, I did hear that. I'm not gonna listen to it. I remember when that happened with Act 1, I think it was, for Beyoncé's Renaissance. It was like the day before stores started putting it on the shelves and selling it, and then somebody put it online. And the overwhelming majority of Beyoncé fans didn't listen to it. They waited, and I'm gonna do the same. I'm not gonna listen to it. That wasn't a part of my schedule, and then that means I gotta change my filming schedule. Like, I'm not doing that. And that is shitty. Yeah, that is shitty. Yeah, they see, and I don't pay attention to those things, so they don't hit my algo. So it's usually somebody telling me, you know, that something happened, or now because we have a Discord, I'll see it in the Discord. But like my algorithm is so fucking tight that on every social media platform, I did not see that Drake dropped or streamed whatever a song. The What Did I Miss? Is that what it's called? Nigga Everything. I did not see that at all. It wasn't until somebody said something in the Discord, I was like, "What? Nuh-uh." 'Cause I was like, "No way did Drake release or stream a song and it's not anywhere in my algorithm?" I was so proud of that. Once I was like, "Let me check again," and went and looked and checked, and it was nowhere. I was like, oh man, I've been doing real good. I've been doing real good." I played like that 3 times, and my fucking algo was like, "Oh, you want nothing but Future? I will burn you to the ground, algo. Burn you to the ground." Shit. But I just, I read the lyrics. I didn't listen to it because I don't care. And I'm really glad I didn't listen to the song because the lyrics pissed me off. So hearing it actually in the format of a mid-ass song would have pissed me off even more. She might say, "No, now, nigga, shut up." Nigga, shut up. Shut your whole face. Go to therapy. Go to couples therapy. Go to breakup former friends therapy with all these niggas you still up in your feelings about. Because they don't care. And we don't care. And then you referenced him here and gave him attention. Don't do that. Don't do that. And you don't know who it was. So don't do that either. Don't give that nigga credit. Don't give him credit for shit. Nothing. Nothing. Ever. Period. Except being a culture vulture. Don't breathe his name on this channel. Unless you have video of him getting mollywopped by somebody. And then we'll be here to discuss it. We'll watch it in regular motion. We'll watch it sped up. We'll watch it in slow motion. We'll watch it with music in the background, okay? I might even do an overlay of fireworks. Yeah, of him getting curb stomped. But anything short of that, I don't want to hear it. I can't stand his little rodent ass. Good. Marshall Irons, I thought about this when I read the lyrics to What Did I Miss? Which, first of all, when I saw that the name of the song was What Did I Miss, I quite literally said out loud, niggas asking rhetorical questions now, huh? This niggas asking rhetorical questions now. We all know the answer. We all know the answer. We also know you don't actually give a fuck about the answer, because if you gave a fuck about the answer, you would not be suing over a rap song. Nigga missed everything. Quite literally everything. And I blame his mama. I sure do. I thought about this the other day. I had an epiphany. I said, oh my God. We've been looking at Tuna Bagel Gate all wrong. Right? I mean, not all wrong. We haven't been looking at it all wrong. We've actually been looking at it quite accurately. But we haven't looked at it in its fullest, you know? At least I hadn't. So my brain finally took it a little bit further. My brain said, hey, chat, you know, just to me. Hey, chat. I was like, yeah, what's up, brain? Brain was like, chat, riddle me this. Drake wanted a tuna fish and bagel sandwich. I was like, yeah. And then his mom went to the grocery store. Yeah. In the deli, they didn't have that. No, they didn't. They had the peanut butter and grape jelly, and he didn't like that. Okay. But how come she didn't just get the ingredients for a tuna fish salad sandwich bagel situation and hand him the bag of groceries and say, make it yourself? I hex you, Sandra. I hex you. Now we all got to go to fucking court because you didn't teach this nigga how to be self fucking sufficient to make his own goddamn tuna fish bagel. Now we all got to register our government names. Like we're fucking Dr. Dre dapping up the wrong person at the Grammys. The fuck? Goldie. This cracks me up because I know Goldie's actually thinking about it. Goldie's like, wait a minute. Wait a fucking minute. Why didn't she just get the ingredients? Why didn't she just get the ingredients and say, here, do it yourself? A rhetorical question. We all know why. Rhetorical question. We know why. You're in a grocery store with all of the ingredients. This is not complicated. Shit. Thank you, Mika Red. Amen. Damn you, Sandra. Damn it. And then there's this. And then there's this. I got you what I got you. Are you hungry or not? You're a fucking television star with a salary. Get your own goddamn food. You're 18. Get your own fucking food. Marshall Irons. First one to complain is the next one to cook. Yo, mama smart. That's a good strategy. Yeah. I don't think Drake has cooked anything in his life. I don't think Drake has cooked. I just can't imagine Drake cooking. What does Drake cook? For real. Nothing. Nothing. I cannot imagine a single fucking thing that Drake cooks. No. That's a good one. That's a good one. Drama. Ooh, this Kiki, you always come through with a good fucking answer. He probably know how to make pancakes. Fair. Fair. He probably does. He probably does. I'll take that. I thought about cup of noodles, but I don't think he's smart enough. I don't think that he's smart enough. I don't think that he's humble enough to appreciate a cup of noodle. You don't have to, but you could sear it if you wanted to. You still have to assemble it. You still have to chop ingredients. Ugh, God, I hate that fucking mirror. Grilling hot dogs in front of his liquor mirror. Yeah. Claudia, I wouldn't trust him to warm up tortillas. Damn. But fair. You know why? Because he's going to be too busy making duck lips into the phone as he takes the selfie. Your tortillas are going to burn. I always pour the dehydrated veggies out before I add the water. I don't need your dehydrated little stupid veggies. That's not why I made this. I made it for the sodium. I've always done that. Pop the lid, tear the lid just a little bit, pour out whatever falls out, and then add my water. Fold the thing back over, stick my fork on top of it, let it sit there for 3 minutes. Yes, I still eat cup of noodle for whatever reason. When I was pregnant with my daughter, who's my oldest, cup of noodle and Lay's potato chip. I had the worst morning sickness. It was it was it was unbelievably bad. And for whatever reason, cup of noodle and Lay's potato chips didn't make me nauseous, didn't make me vomit, and would settle my stomach. And pretty much ever since then, it's kind of hardwired into my gut at this point in time. If I get a stomach flu, I'm I'm making sure that I have a cup of noodle and I have Lay's potato chips. Also the dehydration and the salt and all of that. It just works itself out. I don't argue with it. I just drink as much water as I can and rock with my little cup of noodle. It's not my preference. It's not because I think it's the best, ramen option out there on the shelves. It's definitely not. It's because it's literally trusty for me. Trusty. And it's fast. Super fucking fast. So, yeah. You don't like the crunchy piece of celery hide? Can't get that just anywhere now. So funny. Yeah, cup of noodle really does have a nostalgic place in my heart and my gut. Can't make me hate it. I don't care. They come out tomorrow and be like, it has arsenic in it. I'd be like, well, who's surprised? Who's surprised by that? Look at it. Fast is so key when you're not feeling well. So key. Because you'll get a window of, I feel like I can eat something right now and I'll be okay. And you need that. You need that. Because the other thing is, I've learned so much about my gut between pregnancy and post-traumatic stress. Um, you can't follow the brain's instinct to not feed yourself when you're not feeling well. You have to eat. Have to. Or you'll just cause a circular problem and a growing circular problem. So it sucks, but that's what it is. When I realized that this was actually a no-no, I was like, you must be joking. You think niggas is putting the kettle on the stove to boil some water for their cup of noodle? Kettles weren't like they are now, where you just push a button and the shit heats up because it's plugged into the wall. No. You gotta put that shit on the stove and wait for it to boil. You think niggas wasn't doing that? That shit went directly into the microwave every single time. I don't know what they were thinking. That's like when Uno is like, actually the rules are maintain your station. With that, how long we been playing this game? Ain't nobody ask you for no actual rules. We're good. Hood rules. See? My go-to when I'm sick is pork flavor packet noodles with soy sauce and chili sauce paste. That sounds bomb. That sounds bomb. I might need to have some Thai food tonight, y'all. I might need to have some Thai food tonight. Uno be noisy as hell, just bossy. Again, ain't nobody ask you, dog. Ain't nobody ask you. Then we got social media. Then Uno got social media. They be insufferable. You can't actually, nigga. Yes, you can. Yes, you can. Come over to my mama house. Tell me what we can't do with the Uno cards. Okay, then. Oh my God. The official Uno rules will turn, docile Uno players into some angry spades players real fast. Real fast. Fateless, this is it. Exactly. I only learned this in the last 5 years. It's only been in the last 5 years that I've learned you're not supposed to put a cup of noodle in the microwave. And that's absurd. That's absurd. It did not change my behavior. What changed my behavior was a plug-in kettle that heats up like that. Well, that's good enough, I can wait the extra minute for that versus the microwave because microwaves are bad, period. But yeah, no. Princey's like, oh my God, was he here? Do I smell him? He was here. You were sleeping. He came in. He was on screen. Come on. Come on. I hate it when you do that, Princey. Are you coming? Come on. Oh, you motherfucker. Come on. Princey gets right to the point that he's going to jump on my lap and then he walks away. He just did that twice. Are you going to come over here? Oscar was here. He was on screen. The people said hi. Princey's like, I just woke up. Is it breakfast time? No, it's not. You coming up? Here he comes again. Come on. He's purring so hard. Come on. It's a lap. It's right here. Jump up here. Come on. I'm ignoring you. This is accurate, Tim Tillman, sorry. It's been a while since I've seen a group of Black people play Taboo, but it's like being on the floor at the New York Stock Exchange. Yeah, that's a good one. That's a good one. Right? And that's on them, Kiki. They been new. They been new. That's not a habit you're gonna break. First of all, poor people eat your food. It's a convenience item. You know what's convenient? Quickly heated up food. You know what does that? A microwave. Styrofoam was cheaper. I don't remember literally ever seeing that. But then again, I wasn't looking. I'm just looking for the essential directions are on the top. Step 1, peel off the plastic. Step 2, pull the lid back no more than halfway. Step 3, fill up with water to this line. Step 4, cook for, well, cook where? I'm not putting it on the stove. It's not going in the oven. They know that motherfucker's going in the microwave. They know. They know. Well, y'all, I'm going to go deal with this little boy. I still have a bunch of boxes that I have to break down. The recycling in the kitchen is insane this week. I don't even know. Well, it came from y'all. I was about to say, I don't even know where it came from. It came from y'all. I'm not complaining. I'm going to break those boxes down with joy. But yeah, I got to find some food, break down some boxes, do some laundry, take a wonderful bubble bath. Thank you again. And I will see y'all. I don't think tomorrow unless something happens. But I will be seeing you on Friday for the fucking finally. I was gonna say long anticipated. I mean, 16 years is a long time, but really, they only made us. Their promo was like 6 weeks, 6, 7 weeks. A promo. They said we're gonna get it right to you. We're gonna get it right to you. And I'm looking forward to it. And I know y'all looking forward to it too. So we will be gathered here on Friday to enjoy that shit together because we deserve. Yes, we do. We deserve good, nice things. Mm-hmm. Mm-hmm. You hear that, Jid? Get up, nigga. Get up. See y'all soon. Love you. Peace.